Hello, Xcellence family. This is Kristina Suengas, agent concierge for both Xcellence Mortgage and Xcellence Title. I have the privilege of catching up with our title attorney, Paul Sardone. Good morning, Paul. How are you today?
Good morning, Kristina. Doing good. How about yourself?
Doing great, doing great. We appreciate you taking the time. As always, we have a quick discussion on everything title. We'd love to discuss today probate. More often than not, we see many clients. We have now an agent that had a client that did all this due diligence, all this estate planning, met with an attorney, created a trust, actually named the successor trustees. God forbid something happened to her. And sure enough, she passed away very sadly and didn't move any of her assets under the name of the trust. So what happens now?
Yeah, that's actually a very common scenario, unfortunately. So one of the focuses that I have when I help somebody with their estate planning is, particularly when you're creating a trust, right? So if you're doing a will, the will is going to have to go to probate anyways. It's just you saying, this is what I want to happen after I die. The will gets entered into the court for the administered in the probate, and then the judge says, okay, we're going to do according to the will, unless there's some kind of issues where it's contested or whatever. That's the will. But a lot of people do trusts and they think, well, I have a trust. But then when I look at the title of the property, it's still held in their individual name. So one of the key steps that people skip very often is funding the trust, it's called. So unless you move the title of your assets from your individual name to the trust, now none of this kicks in. So in that scenario you're talking about, this person did a trust. They wanted their house, when they passed away, they wanted their successor trustee to be in charge. Now they passed away, the person wants to sell the house, and unfortunately they have to go to probate because they never did that final step of transferring the property from her name to her trust, which then names the successor. So it's a small step, but it's an important one. And it's not only as far as real estate, it's any brokerage accounts, naming the trust as beneficiaries on bank accounts, on vehicles, on other assets that you have. A trust that's not funded is pointless. It's basically a waste of time and money. That a lot of times this is something that's going to cost you $3,000, $5,000, even $10,000, depending on how complex it is to set this up. And these poor people, you feel for them, but unfortunately, title-wise, there's nothing you can do with that trust. Now, it's going to help them when they go to the probate. It's going to make it a simpler probate process because they have this document now that shows that she wanted to do. It's kind of like having the will. So it will help them in that sense, but that's exactly what they wanted not to happen, was to have to go to probate. And now they're going to have to do that. So, and another important thing is when you're transferring your real estate into your trust, people worry about the taxes. So you can still have homestead on a property held by your trust. So your property taxes are, and I got this question from my parents actually when I set up theirs. They've had the house since 1978, and they're like, well, our taxes are, and I'm like, no. When you transfer from yourself to your trust, there's no, we put language. It's an estate planning conveyance. Basically, it's not a real transfer, so it doesn't change your tax basis. Hopefully, that doesn't change, and they continue to allow that exemption. Because it makes sense. Why would it's not a sale? It's the same person. They're just setting up their estate. So there is that scenario that people sometimes are hesitant to fund their trust because of that. So that's not an issue. So it's something that has to be addressed, and it's an important part of it. And I see it a lot of times when people are working with, there's either online estate planning software or firms that are pretty cheap but don't really, it's cookie cutter. It's filling out a form, putting in your information, and here's $500 to do this document. It takes them 20 minutes to plug in info, but there's no counsel behind it, and there's no follow-up on transferring the assets over. So it's important when you're setting it up, do it right. If not, it could be completely invalidated, or it could be a big waste of time and money.
Another question that we get a lot is, do you have to set up a tax ID for the trust? Like when you go to establish the trust and move everything over into the name of the trust, is it required that the tax ID has a trust? The trust is associated with a new tax ID?
The only one that requires it would be an irrevocable trust. That's a whole other discussion, but those are not that common. That's the one that you can't change during your lifetime. And it's treated like you have no control over it. So it's like another entity holding the property. It's done for, it has more asset protection benefits and other benefits. But if you're doing a regular revocable living trust, you don't need a separate taxpayer ID.
Okay, so a big message is make sure, whether you're doing it personally for yourself, your family, or even a client, you do all this work with estate planning and then you don't fund it. It's like you said, a complete waste of time and money. Nothing was accomplished. So we want to make sure that we understand that all the assets have to be moved into the name of the trust. The trust owns them now, no longer the individual, correct?
Correct.
Okay. Now, can you just share with us briefly what happens with probate? Because we hear that big P word, we don't know what comes with it. Like what actually happens? What is required when there is the probate process that needs to kick in? Just quick steps, what happens from there?
Well, I mean, there's different types, but in most cases, the simple probate. So when you say it has to go through probate is actually a court action. So there has to be a case filed with the probate court, and then a judge basically reviews the petition, will review the living will and testament if there is one. In the case of this recent client, I'm sure they'll submit the trust as evidence, and then basically you're leaving it in the court's hands to decide how your assets are distributed. There's creditors who have a time period to file a claim, so you have to publish it and then say, hey, this is the estate of John Smith. If any creditors are owed money, you have to file. So it could be a lengthy process. It could be a few weeks. I have seen probates that take a few years. And another problem with it is it could get expensive. Yeah, it could get expensive because usually a probate attorney will charge a percentage of the estate. So whether it be a couple points on it, an estate is valued by the assets, not the liability. So if you have 5 properties, each worth, $500,000, that's a $2.5 million estate. Even if you owe $2 million, and then now you're going to pay an attorney a fee based on the value of the estate, could cost you $40,000, $50,000 in attorney's fees before it's done, that you could have avoided with the proper estate planning. So it's the time, the expense, and the uncertainty of it, because you're leaving it up to somebody else, basically, judge, to determine how it's going to happen, as opposed to maintaining that control and saying exactly what you want to happen and skipping that whole process, which is what we try to help people do.
And we can help our clients with that, correct? The estate planning process.
Yeah, it's different. We can either set up, most people, they come to see me, maybe they have a property, they want to make sure, and all they have is that property. We can do a life estate deed to make sure that property goes to the right person. Other people have several properties, or they want to leave other assets, or they want to put specific clauses in there about how they want money to be managed once they're gone. It's more complex. So in those cases, we'll set up a trust. But it's case by case, but we'll look at it and figure out what the best option is for the client.
Well, we appreciate the insight on probate. I know it's kind of like the big P word. Nobody wants to discuss it. Everybody wants to avoid it.
Yeah.
People try.
In our world, when there's a closing, when there's a closing and all of a sudden there's probate, it's a nightmare. But it happens, and we get through it.
Yeah. And I think, the key is to do your homework up front, do your research, make sure you move those assets. If it's, if you are going to set up that trust. It was just so sad the other day. We saw that this woman had done so much planning and really essentially didn't complete the process, right? So now we start with a probate. We appreciate insight you can provide. It really is, because she wanted it to make easy for her kids, and now they have to go through this process. But
time and expense of it, activation
that she was trying to avoid. So don't let that happen to your client. please reach out to us if you have questions. Paul is amazing. He has a lot of background experience in this. He knows the common pitfalls. He can steer us the right way. So don't hesitate to reach out to us. You can reach us at support@excellencetitle.com. You can call our corporate line 305-595-7355, the option for title, and we are glad to help out. Paul, as always, thank you for your time. Thank you for supporting us. And we wish everybody a fantastic week.
Thank you.
Thank you. Bye-bye.